We're excited to talk about the emerging trends in non-compete law. My name is Adrienne Jack, and I am a Vice President of Legal Product here at SixFifty. I work in a lot in the employment law area, but also in some other areas of law. And also presenting today is Adam Wright. He is also an attorney and also a Vice President of Legal Product here at SixFifty. And he really has delved into the employment law world as well as other areas of the law. So we're excited to speak with you today and look forward to this presentation. Before we get started, I want to talk about some of the different types of restrictive covenants that are out there. During this webinar, we'll refer to restrictive covenants throughout the webinar. And so we want to take a step back and look at those. So that's how we'll start this presentation. And then I'll kind of dive into the basics of non-compete law, what it takes to have an enforceable non-competition provision. And then we'll turn the time over to Adam, and he will talk about some of the trends we're seeing in federal and state law with regards to non-competes. And then finally, we'll talk about how to use technology to comply with the ever-changing employment laws regarding non-compete agreements. And then if there's time at the end, we'll answer any questions that you have that we haven't answered throughout the webinar. So we'll go ahead and get started. As I said, when we refer to restrictive covenants throughout this webinar, it's helpful to take a step back and define exactly what those types of restrictive covenants are. So first, they're non-compete agreements. And those are contracts between a company and employee where the employee agrees not to compete with the company for a certain time period after that employee's employment ends. Then we have non-solicitation provisions. And those are a contract between an employer and an employee where the employee agrees not to solicit the company's clients, employees, or other individuals with whom the employee worked at the company for a certain time period after that employee's employment ends. And then lastly, we have non-disclosure provisions. And those are a contract between an employee and a company where the employee agrees not to disclose the company's confidential information. Often, non-disclosure provisions are for an indefinite period of time, but they could also have a time limitation like non-compete and non-solicitation provisions. So we would like to know through this poll, what kind of restrictive covenants does your company use? So we'll pull up a poll question and please submit your answer. Does your company use non-compete provisions, non-solicitation provisions, non-disclosure, several of the above, or none of the above? And this can give us an idea of kind of what companies on this webinar are using it and will help us tailor our presentation to those kinds of comments. So go ahead and submit your answer. We'll maybe give 30 seconds or so to submit an answer, and then we'll see what those poll results are. Okay, let's go ahead and check those poll results and see what your responses were. Wow, so it looks like the majority of you, 80%, use a combination of those types of provisions. 10% use only non-disclosure provisions, and 10% use none of those. That's really interesting and kind of what we would expect. A lot of companies use NDA or non-disclosure types of provisions. And so that's really helpful information. Great. So the ideas, so let's go ahead and move forward a slide. The idea of a company controlling former employees' actions after those employees leave their employment with the company, that's a limit on free enterprise and also limits an employee's right to make a living. So these types of non-compete provisions have clear limitations. Non-compete provisions often have the most limitations because they are the most restrictive on an employee's ability to work, but also non-solicitation provisions have limitations as well. And non-disclosure provisions are the least restrictive of these three. Some states do not allow non-compete provisions at all. And even in states that do permit non-compete agreements are adding more and more limitations, as Adam will talk about in his portion of the webinar. So of the states that do allow non-compete provisions, these provisions must meet certain requirements. Courts will not enforce a non-compete provision if there is no legitimate business interest for the restrictive covenant, if the employee is in a certain industry or has a certain type of profession, if the restricted period is too long, if the restricted area covers too much territory, or if there are too many other limitations on an employee's ability to earn a living. I'll talk about each of these in more detail. So first, in order to have a non-compete provision be enforceable, sorry, we'll stay on that slide for a minute, there must be a legitimate business interest. State law defines and determines what is a legitimate business interest, and this varies from state to state. So some protectable business interests could be the company's trade secrets, customer relationships, goodwill, specialized training, confidential information such as pricing information, customer lists, business strategies, or financial information. But a company's desire solely to limit competition is not a legitimate business interest. The burden is on the company seeking to enforce the non-compete provision to provide that legitimate business interest. And this legitimate business interest is not in the absolute. It must be weighed against any interest employees might have in the customer relationships. For example, if an employee took an active role in bringing a customer to the company and had a robust relationship with that customer, then the court might be more reluctant to enforce restrictive covenants against that customer because the employee had such an active role in bringing that customer to the company. Second, in addition to a legitimate business interest, there are limitations on who can enter into restrictive covenants. Generally, a company will have a difficult time establishing a legitimate business interest to support a non-compete agreement against a low-wage employee or an employee who does not have access to company confidential information. And this is one of the popular trends that we're seeing that Adam will talk about in great detail. Additionally, states have laws that prohibit non-compete agreements for employees in certain professions. The most common of these is that many states prohibit non-compete agreements with physicians or attorneys, but some states extend this prohibition to accountants, veterinarians, physical therapists, broadcasters, or other professionals. And like I said, this is very state specific, so each state will have a different list of who can enter into restrictive covenants and who is prohibited from entering into them. Also, so once there's a legitimate business interest and the employee is the type of person who can enter into a restrictive covenant, the restrictive covenant must protect the business interest without being so broad that it imposes an undue burden on the employee or on the public. So that means the restrictive covenant has to be reasonable. And whether a restrictive covenant is reasonable is a million-dollar question. And that really hinges on the facts and circumstances of that particular instance. So there's no clear bright line rule for what is reasonable. It depends on each specific instance, on the factors of the employee, about the company, the situation when the restrictive covenant was entered into. And this differs state by state. So one situation where a restrictive covenant might be completely enforceable, in another state might not be enforceable. So this gets complicated quickly. Into determining what is reasonable, courts look to several factors, including what's common practice in that company's industry, what is the company's business, what is the location or geographic scope of the employee's work, how long after employment or was it upon employment that the restrictive covenant was signed, the circumstances of why the employee left the company, the length of time required to hire and train a replacement for the employee. Those are just some of the factors that the court will look to. And so it's hard to know in specific instances what might be reasonable for a restrictive covenant for an employee. But some factors that companies definitely should be looking at is first, the length of the restricted time period. This must be reasonable. The shorter the time period, the more likely it is that the restrictive covenant will be enforceable. In many states, there's no standard restricted time period. In a handful of states, they have a period of time that is considered presumptively reasonable for non-compete provisions. For example, in Georgia, a restricted period of 2 years or less is presumed to be reasonable for a non-compete agreement. And in Florida, a restricted period of 6 months is presumed to be reasonable for a restrictive covenant. However, this presumption can be rebutted if based on the particular facts of a case. Other states have varying lengths of time that are routinely used for restrictive covenants. The most common types from state to state, the most common length of time period is usually 1 to 2 years for a restricted period. But we'd like to know in this next poll, what restricted time period does your company most frequently use for non-compete provisions? So the answer options will appear on the poll, but how long are the restricted period for your non-compete provisions? Are they 6 months or less? Is it 1 year? Is it 2 years? Is it more than 2 years? Some other time period? Or do you not use non-competes? And so this question is not applicable to you. Can we go ahead and pull up that second poll question? And then feel free to submit your response. And if you are not currently using non-compete provisions, if you were to enter into them, what time period would your company use? Okay, we'll give you 10 more seconds to vote, and then we'll pull up those responses. Okay, let's go ahead and pull up the poll responses and see what your answers were. So it looks like the majority, 60%, use a time period of 1 year, and 20% use a time period of 2 years. So that's is what we would likely anticipate, because 1 to 2 years is the most common time period that we see from state to state, but some use 6 months. It looks like nobody uses more than 2 years, but some of you do use a 2-year time period. So that's helpful information and squares with the information that we've seen from various state laws. Okay, thank you. In addition to the restricted time period being reasonable, the restricted area for which the non-compete applies must also be reasonable. How large of an area is reasonable will depend on the industry and the employee's position at the company. A court is more likely to find a non-compete reasonable if it applies only to a limited geographic region in which competition would truly undermine the company's business. However, this varies from position to position at the company. For example, for executive or senior level employees that are involved in company-wide high-level strategy and decision-making, the company might be able to restrict that employee from competing in all geographic areas where the company does business. So the entire scope of the company, wherever that company's footprint is, they might be able to enforce that against a top employee such as a C-suite executive. However, for most employees of a company who don't have that same company-wide high-level role, the geographic area should be limited to those areas where the employee worked or provided services for the company. So it shouldn't apply to every place that the company does business, but specifically where was that employee working, and tailor that time period accordingly. So in addition to the restricted period and restricted area, the scope of the protected activity must also be reasonable. This means that the employees should only be prohibited from doing similar activities for a direct competitor of their former employer. A non-compete provision that prevents an employee from working in any capacity in their former employer's industry is unreasonably broad and likely unenforceable. Additionally, a non-compete provision must be limited to preventing the employee from doing business with customers that the employee actually worked while with the company. So it might be difficult to enforce a non-compete against all of the company's customers. However, it's likely enforceable to be able to enforce that restrictive covenant against the customers that the employee actually worked. In some states, there are limitations on whether a company can prohibit a former employee from soliciting only prospective customers of the company. In some states, it truly has to be limited to current customers of the company that the employee worked with while they were employed there. And so it varies by state, but some states do have those kinds of additional limitations. Just as what constitutes competition must be reasonable for non-compete agreements, similarly, what constitutes solicitation must be reasonable for non-solicitation provisions. Non-solicitation provisions can prevent a former employee from soliciting customers, employees, or other individuals such as vendors, contractors, or suppliers. A non-solicitation provision can be limited to only one of these groups or can apply to several of these different groups, but should often be limited to only those individuals with whom the employee actually had material business contact. Okay, we can move forward a slide. So in addition to these kinds of limitations, there are other elements that a non-compete provision has to have in order to be enforceable. Companies must provide consideration to employees for the employee to enter into restrictive covenants. So by signing a non-compete or non-solicitation provision, employees agree to give up a right they would otherwise have. So the employees should receive something in exchange for giving up that right. And that's what we talk about when we say consideration, is what are employees receiving in exchange for giving up this right that they might have to compete against the company. Typically, an offer of initial employment is sufficient consideration. So if you're hiring a new employee and ask them as a condition for this new employment to sign a non-compete, that's likely sufficient consideration. In many states, also, continued employment is considered sufficient consideration to enter into a non-compete or non-solicitation provision. So if you have employees that are already employed that you want to ask to sign a non-compete or non-solicit, in the majority of states, it's sufficient to say, and we'll keep you employed by agreeing to sign this agreement. However, some states have specific requirements of what constitutes adequate consideration. So Illinois, for example, you have to provide adequate consideration to enter into non-competes, and this is defined as a period of employment for 2 years. That is, so if an employee enters into a non-compete provision, it's only enforceable once the employee has been employed for 2 years, or it can also be financial or professional benefits, such as a lump sum cash bonus that would be considered sufficient consideration in Illinois. So once the consideration element is satisfied, some states also require that companies provide notice of the restrictive covenant to employees before they are asked to sign it. So some states have specific time periods companies must comply with, and Adam will talk more about this, but this is something to be aware of if you are planning to ask new hires or employees to enter into non-compete agreements. You might have to give them a certain amount of time period or notice that they will be asked to sign this agreement, and maybe other information such as that they should consult an attorney before signing it. Okay, we can move forward to the next slide. So what happens if a restrictive covenant is unenforceable? Because the restricted period is too long, the geographic area is too broad, or other reasons. There are several results that can happen from this. Either the provision that's unenforceable can be selectively enforced by a court, it can be modified so that it becomes enforceable, or it can be entirely disregarded and thrown out. These different approaches are known as blue pencil or red pencil. The term blue pencil means a court will strike the unenforceable parts of that restrictive covenant to make it enforceable. Some states will also allow a reformation or a rewriting power. So the court has discretion to rewrite the unenforceable parts to make it enforceable. And about 2/3 of states allow this power to rewrite the parts of the restrictive covenant that are unenforceable. But the extent of this power varies. In some states, courts will are only allowed to rewrite certain provisions of an unenforceable agreement, such as they can only rewrite the restricted period. If it's too long, they can rewrite it to be for a shorter time period. In other states, only the protected activity can be revised. So how you define competition, if it's too broad and too expansive, the court might have authority to rewrite that to tailor it back so that it becomes enforceable. And in other states, courts are required to rewrite the restrictive covenant so that it becomes enforceable. So that is all typically known as blue pencil. So red pencil is when a court will not enforce any part of a restrictive covenant if any part of that covenant is unenforceable. As far as enforcing restrictive covenants, this is the worst case scenario because the entire provision is thrown out and not enforced against the employee. And only a handful of jurisdictions use this approach, but the outcome can be severe. So these are, and also in addition to striking or rewriting the unenforceable provision, there can also be monetary penalties associated with unenforceable non-competes imposed on a company, or a company might be required to pay attorney's fees to employees who strike down an unenforceable non-compete provision. And Adam will talk more about some of those penalties and the trends that we're seeing in that area.
So Adrian gave us a great overview of the basics of non-compete law, what it is, when non-competes are enforceable. So let's shift now to talk about trends that we're seeing in non-compete law. And non-compete agreements are under increasing scrutiny across the country. It's a really interesting trend. It's a dynamic area of the law that's moving quickly and changing rapidly. And it's not hard to understand why non-competes are coming under fire, right? As Adrian mentioned, they restrict people's right to or ability to earn a living, to support themselves and their family. And an estimated 40% of American workers have been subject to non-compete clauses. So it's a real issue for a lot of American workers. It affects a lot of people. And so changes in the law have a lot of tangible effects on a lot of people's day-to-day ability to make a living. And so over the past decade, we've seen a lot of these headline-making abuses of non-competes, where companies are using non-competes in a way in which they weren't designed for. So one of the most prominent examples of that is Jimmy John's. And in this case, Jimmy John's got in a lot of legal trouble for using non-competes for their low-wage sandwich makers. And so they were prohibiting them from working for other sandwich shops. So a Jimmy John's worker couldn't go work at Quiznos or Subway, for example. And because of that, Jimmy John's was subject to investigations by attorneys general in several states. But because of stories like this that made headlines, I think states have become really aware of the overuse of non-competes. And so states have really started to take a close look at how each state's non-compete law works. And we'll talk more about the steps that states are taking to rein in the use of non-competes. But as Adrian pointed out, non-competes do play a really important role in protecting legitimate business interests of a company. And so I would say what we're seeing, a broad overview of the trend that we're seeing, isn't momentum toward outright banning non-competes, although there are a few exceptions that we'll talk about, but rather a more nuanced approach to limiting their use. Okay, let's go to the next slide. All right, so let's look at trends at the federal level. So this made news this summer, you may have seen. So in July, President Biden issued an executive order encouraging the FTC to curtail the unfair use of non-compete clauses. So I think there is a lot of confusion about what does that mean for companies now? What's the effect of this executive order? So immediately, it doesn't have an effect for companies that use non-competes, right? So the executive order itself doesn't ban non-competes, it doesn't limit non-competes, and it's not even encouraging the FTC to outright ban non-competes, but it's, again, focused on reining in the, quote, unfair use of non-compete clauses. So what does that mean? That remains to be seen, right? We don't know exactly what the FTC is going to do to rein in the unfair use of non-competes. It's not entirely clear what the executive order means when it uses unfair use of non-competes, but it probably means things like overusing them for low-wage workers. So, you know, it may be some time before we see what the effect of the executive order is, because the FTC is going to have to go through a rulemaking process. If and when it issues a rule on non-competes, there's almost certainly going to be legal challenges to that rule, because non-competes are part of contract law, which is traditionally an area of state regulation. And so there are undoubtedly going to be legal challenges to the FTC's authority to issue rules on non-competes. So I think we can expect any rule to be caught up in legal action for a while before it goes into effect. But what I think is important to take away here is that the executive order does reflect a current widespread skepticism across the country over non-competes. And I think now it really highlights that now is a good time for companies to rethink how they're using their non-compete agreements. One other thing to note at the federal level is that there has been some legislative movement as well. So there have been several bills introduced in recent years by senators ranging from Elizabeth Warren to Marco Rubio. And the various bills take different approaches. Some seek to, outright ban non-competes. Others take a more limited approach and seek to ban them just for low-wage workers. But to date, none of those bills have passed. But again, I think it's just sort of highlights the trend that we're seeing across the country. We can go to the next slide now. So let's talk about trends at the state level. There are 3 states that outright ban non-competes, and that's California, Oklahoma, and North Dakota. Washington, D.C. has passed a law recently banning non-competes as well. And so they are set to join those 3 states in banning non-competes. That law is set to take effect in April, I believe, of 2022. But there has been another bill introduced now seeking to scale back the new law. So that remains to be seen, the extent of what DC's law will do to non-compete. So stay tuned for that. But there are many states that have specific statutes that limit the use of non-compete agreements. And those states include Colorado, Illinois, Maine, Maryland, Massachusetts, New Hampshire, Nevada, Oregon, Rhode Island, Virginia, and Washington. And those are just examples to name a few. So we're going to put up another poll question here. And we're curious to know, several of you stated in the last poll that your company does use non-competes. We're curious to know if you are aware of the specific restrictions on non-competes in the state or states where your company has employees. So we'll give you a few, maybe 30 seconds to answer this question, and then we'll take a look at the results. All right, let's take a look and see how everyone answered. All right, so the majority of responses, people here are not familiar with the specific restrictions on non-competes in the states where your company has employees. So we will get into this in a minute, but this is that is great to know. It's certainly something that companies need to be aware of, and increasingly is becoming more risky not to be aware of, and we'll talk about why that is in just a minute. Okay, so we can move on to the next slide. So what can we expect? I think it's pretty clear that we can expect more state level restrictions in the near future. Again, the quickness in which the law is changing here is really breathtaking. Over the past several years, 37 states have been reevaluating their non-compete laws, and 24 of those states and DC have actually made changes to their non-compete laws. And you can see that reflected in the map here. The highlighted states are the states that have actually made changes to their non-compete law in recent years. And in this year alone, there have been 66 non-compete bills introduced in 25 different states, which span the political spectrum from Mississippi to Vermont. And I think that's a really important point here, is that this isn't a red state, blue state issue. It really is a trend that we're seeing, across the political divide. And so it's important to be aware of that. So let's move on to the next slide and talk about the specific approaches that states are taking to rein in the use of non-compete agreements. So first, and this may be the most popular method we're seeing, is that many states are prohibiting non-competes for low wage or low skilled workers. And they're using mechanisms like income thresholds. So for example, in Illinois, under a new law that was passed in Illinois, which will go into effect the beginning of next year, non-competes are banned for employees that earn less than $75,000. Washington and Oregon both ban non-competes for employees that earn less than about $100,000. And so that's a huge swath of the workforce in Washington and Oregon that it's against the law to use non-competes for. Maryland has taken a more conservative approach. So employees that earn less than $31,200 annually or $15 an hour, non-competes are banned for those employees. Nevada has taken an interesting approach and just outright banned non-competes for all employees that are paid an hourly wage. Massachusetts has taken a similar approach and banned non-competes for all non-exempt employees under the Fair Labor Standards Act. And non-exempt, broadly speaking, just means typically those are your low-wage employees that are paid on an hourly basis. There are other states with income thresholds like Maine, New Hampshire, Rhode Island, and Virginia. So if you're in any of these states, you need to be aware of the income threshold and make sure that you're not using non-competes for employees that don't meet those thresholds. And let's move on to the next slide now. So another approach that states are taking is, and Adrian mentioned this, is using notice requirements. And these may be in addition to income thresholds in some states. So many states require employers to provide employees advance notice that signing a non-compete agreement is going to be a required condition of their employment. So for example, and Adrian mentioned this in the new Illinois law, employers have to advise the employee to consult with an attorney and then must provide the non-compete 14 days before the employee starts work. In Massachusetts, employers have to again advise the employee of a right to consult with an attorney about the non-compete, and they have to provide the non-compete at the earlier of either 10 days before starting work or prior to a formal offer. In Washington state, employers must disclose the terms of the non-compete before the employment offer is accepted or before the employment agreement becomes effective. And we'll talk more about this in a minute, and Adrian alluded to this fact, but the consequence of not following these notice requirements can be quite severe. Your non-compete, one, is going to be unenforceable, and two, in some states, you might be subject to civil penalties. We talked briefly about Washington, D.C.'s law. One interesting aspect of that law is that not only does it ban non-competes in the current form, at least, of how the law is written, but employers must affirmatively disclose in writing to all their employees that non-competes are unlawful in DC. And if you fail to do that, you can be subject to a fine. So other states with notice requirements are Maine, New Hampshire, and Oregon. So if you're in any of these states, you need to be acutely aware of the notice requirements. Let's go to the next slide. So, and again, Adrian briefly touched on this as well, but some states are now requiring additional consideration to render your non-compete enforceable. So, and again, consideration is just the benefit that's exchanged. So in this context, it is what the employer is giving the employee in exchange for the promise not to compete. So as Adrian said, historically, an offer of employment is sufficient consideration to make a non-compete enforceable. And that's still true in almost every state, but we are seeing some changes there. And two states that have made changes in that regard are Illinois and Massachusetts. So as Adrian said, in Illinois, you have to give either 2 years of employment or additional financial or professional benefits. Massachusetts law has an interesting piece. It says that sufficient consideration includes garden leave or other mutually agreed upon consideration. And garden leave refers to payments that the employer makes to the employee during the restricted period. So essentially, the employer is paying the employee after the term of employment not to compete with them. But this can be really expensive. So for example, in Massachusetts, the garden leave is 50% of the employee's salary. So, this may only make sense for a small category of employees where it's worth that cost to enforce a non-compete agreement. And then in terms, both in Illinois and Massachusetts, what additional financial or professional benefits or other mutually agreed upon consideration means, those are really loose terms. Historically, courts aren't making a decision on whether consideration is, the amount of consideration is sufficient or not. But what we're typically seeing companies doing, like Adrian mentioned, is giving things like lump sum payments, raises, or promotions to satisfy the consideration requirement. All right, let's move on to the next slide. So this is the last approach that we're going to talk about that we're seeing at the state level. So the penalties, the risks that are associated with using unenforceable non-compete agreements. So state prosecutors across the country have recently become more aggressive in going after companies that are abusing non-competes by subjecting low-wage workers to them. We saw the Jimmy John's example already, but Illinois, New York, and Washington are all examples of states where this has happened recently. So here's a headline, for example, from Washington, where the Attorney General there investigated and a company who was using illegal non-compete agreements and ultimately resulted in a settlement agreement or consent decree where the employer paid $110,000 fine for using non-competes or for using illegal non-competes. And the Washington law specifically provides penalties of $5,000 per violation. So that means every contract. If you have 20 employees and you have unenforceable non-competes in every one of those contracts, you're looking at a really hefty fine there. So I think, you know, this really highlights that it's becoming a much riskier strategy for companies to just, as a matter of course, include non-competes in every employment agreement without giving them a hard look and thinking, okay, do we really need a non-compete provision in this contract to protect a legitimate business interest of the company? All right, let's move to the next slide, please. So, you know, that's an overview of the trends that we're seeing both at the federal and the state level. And here are a few takeaways that I think, you know, are important to go home with. One is that there's a clear and rapid trend both at the state and federal level to restrict the use of non-compete agreements. Two, I think we can expect more states to impose bans on non-competes for low-wage workers. And three, we can expect more states to require potential hires get notice of the non-compete and that employers give them time to review the non-compete before signing. So, you know, I think this highlights that companies really need to stay on top of the law in every state where they have employees, where if they're using non-compete agreements, because there are probably going to be changes coming quickly. Number four, companies should not be using non-competes as a matter of course in every employment contract, what we just talked about. And of course, that means that now is a good time for companies to take a fresh look at how they're using non-compete agreements. So that's an overview of the trends that we're seeing, again, at the federal and state level and non-compete law. And Adrian, if we received any questions that would be good to try to answer at this point?
I think we've tried to answer them in the Q&A function, so I think we're good on that front.
Okay, well, I will turn the remainder of the time back over to Adrian.
Yeah, and let's move forward to the next slide. So as you can tell, there are a lot of moving pieces here that companies need to be aware of. So even within a company, you can't use this, you may not be able to use the same non-compete agreement for every employee. So employees are in different states, they're in different employment positions, they have access to different information. So there are so many considerations that companies need to think about when entering into their non-competes. They need to evaluate, is there a legitimate business interest? And that depends on what state the employee is located. So that's a state-specific inquiry based on the employee. Also, is the restricted area that they're using reasonable, both considering the employee's position and considering the state where the employee is working? Is the restricted area narrowly tailored to the employee, to the areas where the employee is working? Also, is there consideration? What are the requirements for consideration for this particular employee, and are we meeting it? Also, is there any notice that we need to give this employee to enter into a non-compete agreement? And then also, companies need to be thinking about what penalties can be might apply if this non-compete is unenforceable, and that would be helpful in determining how to narrowly use a non-compete provision, is considering what kind of penalties could result if the restrictive covenant is not enforceable. So these are a lot of considerations, and that's what prompted us to create an automated tool to help companies solve this problem. There are so many factors to think about. They differ by state and they're changing nonstop. As Adam mentioned, we saw a lot of bills in the legislature to change how to rein back restrictive covenants, and this is a lot for companies to keep on top of. So our tool that is coming soon will help companies walk through a series of questions for each employee that they'd like to enter into a restrictive covenant, that walks them through each of these considerations that we talked about to help them ensure that they have a narrowly tailored and reasonable non-compete agreement, and that it's enforceable against the particular employee that they're entering into it with. And we think this will be very valuable to help companies stay on top of this evolving problem that can get complicated very quickly. So stay tuned for that. And we also have other employment products, such as employee handbooks, return to work, to help companies get employees back to the workplace during COVID-19. And if you're interested in checking out any of these tools, you can go to 650.com/employment. And we have all of our resources there. And also that's where we will be launching this new tool to help companies enter into employment agreements that have restrictive covenants that are enforceable based on the specific facts of the company's employees. And so with that, it looks like we have a couple questions, and we'll see if those would be helpful to talk about live. And if not, we will either answer them in the chat or in the Q&A function, or we'll send them out to the with the slides of the webinar if we need some more time to follow up on those. So we are so grateful that you joined our webinar today. Adam, are there any questions that might be helpful to talk about live, or are we handling those right now?
I think we're handling them. There are a couple that are probably pretty specific, I would say, that probably aren't applicable to most people in the webinar. So if we haven't answered your question, we will answer. We'll get back with you on those questions.
Okay, thank you. Well, we'll be on for a minute or two to answer any questions, and feel free to submit those. Otherwise, thank you so much for joining today, and we hope you check out our employment products at 650.com/employment.
Hey guys, I thought I might just hop in for a second with a question that rung a bell for me because I deal with this somewhat in my role over here at 650. One of the questions that came in from the Q&A was asking whether there are recommendations on effective controls or tools that could help protect your source code. So this is, particularly going towards companies that have some sort of intellectual property that they're trying to protect. And this is where I think, and this is one of the things that the tools that Adrian was talking about are going to be really helpful, is in addition to these types of restrictive covenants, you also have the ability, so we've been talking a lot about the non-competes, but the NDAs themselves generally are easier to enforce in some ways than non-competes are, because of the interest that you have in your intellectual property. So binding your employees through an NDA so that they can't, reuse your source code, take it to a competitor, any of those things, that type of enforcement of a non-restrictive covenant from my perspective is a lot easier in the majority of courts. Would you guys agree with that, or have any other thoughts on thoughts of the difference between sort of like an NDA and a non-compete?
Yeah, I mean, I think you hit the nail on the head there that, NDAs, there is sort of automatically a legitimate interest of the company there in protecting their intellectual property. And because of that, I think it's a much safer route or easier route to enforce for protecting your intellectual property like source code.
Perfect. I think we're going to go ahead and wrap up the webinar then. And if we didn't get to your question, it might be very specific. We'll follow up after the webinar. So thanks again, and we hope you enjoyed this webinar.